Good afternoon. We'll call this meeting of the Civilian Appeals Board to order at this time. And Ms. Claudia, will you do a roll call?
Sophia Brewer.
Here.
Reginald Howard.
Here.
Jason Osborne.
Present.
Russell is out sick, and Michelle could not attend in person.
Both Russell and Michelle will be watching via Facebook, so they still receive today's training. All right, the next thing on our agenda is an approval of the 9/21/22 meeting minutes. Can we have a motion?
So moved.
1 second.
Seconded.
All right, any discussion? All those in favor?
Aye.
Any opposed? And any abstain?
Abstain.
Okay. And with that, I think it makes sense that we introduce our newest board member, give you an opportunity to introduce yourself, and we just like to formally welcome you to the board.
Thank you. Well, it's a pleasure being here. It's an honor being able to serve the Grand Rapids community. It was quite a surprise to get the notice that I was appointed to this board, and I look forward to serving with honor and distinction and promoting the best community that we can have.
Thank you so much. Welcome. Okay. The next thing on our agenda is the board liaison report. I have very little to report on today. I did hear that there was a great training at GRPD. I believe that was last week when the use of force training was offered. I heard extremely high reviews, both from board members and from OPA staff. So special thanks to GRPD for providing such a great training and helping this board to move forward in its understanding of GRPD's policies. The next thing is that we do know that there is a pending appeal that we received, I believe, about 2 months ago now. Originally, when this was discussed, I indicated that we would be hearing that appeal at the November meeting. That was our plan based on what we thought would be our training schedule. Based on the amendments to our training schedule, to get this board up to speed, we are planning for that appeal to be heard at the December meeting. And we believe that we'll be able to conclude all of the required training at the November meeting. And with that, that concludes my report. Any questions related to that? We anticipate being able to get materials for that appeal to you all at or around the November meeting as well. All right. With that, we'll move to the meat of today's meeting, which is training. There are two topics we'll be covering today. One is the history of the Civilian Appeals Board, which will be presented by our legal counsel. And then after that, we will have an introduction to the Internal Affairs Unit that will be presented by the Internal Affairs Unit. So we will hear from them in that order.
All right. Thank you to the CAB members that are here and to any of the CAB members and public that are joining us virtually. Thanks for those in attendance of the audience. I'm going to try to be rather quick with this training, not to give any short shrift to the information, but open it up for an opportunity to reach out after the fact. I will note for the CAB membership, I've sent out a handbook that's published by the Attorney General for both FOIA and the Open Meetings Act that provides quite a bit of supplemental information. And so I will go through those topics with relatively quick overview. But I did think it was important for you to all know kind of the history behind CAB and some of the challenges that have been at the forefront of other CAB members as they've served in this role. You'll then hear from the IA department, from the Grand Rapids Police Department, and it's much more important, I think, that you get their information. We can talk history for days about oversight and different agencies that look at police work, but I'm going to go through this material relatively quick. We did send the PowerPoint and the supplemental stuff out previously, so here we go. Here's what we're trying to cover today, the legal history and some context related to the current CAB system that we have. The legal topics include Open Meetings Act, Freedom of Information Act, City Commission Policy 100-06, Michigan Public Employer Law, which will be a deeper dive at the next available training. That includes collective bargaining and civilian appeals board. The Disclosures by Law Enforcement Act, which are Garrity statements or Section 8 statements that we refer to, and also constitutional considerations. Those last three topics will really be dove into in the next training. We can't cover it all here today. It is sometimes hard for lawyers not to talk like lawyers, so forgive me if I go on a little bit of a legal tangent or use legalese during my presentation. I'm really fascinated by the history of oversight for the Civilian Appeals Board, but also just generally oversight of government in Grand Rapids and throughout the state. So I get excited when I get an opportunity to talk about this stuff. So feel free to ask me any questions, but let's try to email questions too if you have them, or give me a call and I can do some more one-on-one training if it would be helpful. I want you to think a little bit about the municipal evolution of Grand Rapids as a city and also in the context of the police department. So it was 1837 when Michigan became a state. The city was incorporated in 1838, and the city was incorporated as a different type of municipal organization in 1850. Our city charter was revised and approved in 1857. And then GRPD was formed in 1871. So that's quite a long time ago. There's a rich history there. And if you think about in context the other things that were going on nationally and within our state around those times, it gives you some perspective about some of the language in our charter. Some of it's very outdated and hasn't been updated and maybe could or should be revised. Those processes are difficult. They can be politically challenging. And so charter amendments or charter revisions are not done very often. We've seen some initiated by petitions from the citizens and the voters recently, but there's still certain areas of our charter that I think we could point to, and common sense would say we should change it pretty quickly, but the actual process can be more challenging. We have had a state law change with the Home Rule Cities Act in 1909, and that gives us some establishment to rely on for our role as a city within our state and the county government systems. We've elected to have a city manager form of government. You may hear other governments that have a strong mayor form of government. In Grand Rapids, we have a city manager who acts as essentially a chief operating and financial officer for our city and leads the day-to-day operations of most of our departments. In 1996, you may have heard about a mandatory police funding from the general fund of 32%. There's been discussion politically about that more recently, whether or not that should be repealed or replaced or increased. There are different political groups that have different perspectives on that, and I would not be surprised if additional advocacy is done around that charter amendment in future, not so distant future years as well. We do have a police and fire retirement system that's acknowledged with our code of ordinances, as well as a police department. If you look at some of the media stories and the headlines around the Civilian Appeals Board, you may see what appears to be public frustration with the Civilian Appeals Board historically. In reality, the Civilian Appeals Board in Grand Rapids has a different, and some would argue more, authority than many other types of civilian oversight boards throughout the state and in other municipalities. Many oversight from civilians is merely advisory, so you can make recommendations and opine or have opinions on certain things, but there's no mandatory or actual true action that the Civilian Appeals Board does in different municipalities. In Grand Rapids, there is a function that has been developed, as we see over time, that allows you to review the findings of the Internal Affairs Department and potentially change those findings so long as it's done in a legally valid way. So in 1995, there were discussions about the need for civilian oversight for the police and the history of policing in Grand Rapids. It led to kind of a national look at what other departments in the state had, and in 1996, 6 departments in the state had such boards and panels with varying degrees of influence. You can see a quote from one of those boards highlighted here on this page. This commenter said, "It wasn't a true review board. I don't know if very many exist. These are very difficult matters. You're trying to balance competing interests." And the board provided an avenue for citizen complaints, but officers are also protected by union contracts that allow them the right to independent arbitration in discipline matters. That's not untrue today. Our officers are employees of the city and are subject to the Michigan Public Employee Rights Act. And we'll talk more about that and the implications and how the Civilian Appeals Board is required to a certain extent to understand how that works with city employees. There was a study done where a commission turned into what was the first iteration of the Civilian Appeals Board in Grand Rapids. But what is true now was true then. They needed to be trained as the first civilian appeals board on many of these legal considerations and the policies related to policing before they could really roll their sleeves up and hear the cases and do the work. And so I maintain that that was the right decision then. It's the right decision today to make sure that members of the Civilian Appeals Board are adequately trained and have a good foundation of knowledge before they're asked to make decisions that impact both citizens that might have been subject to investigation by a police department employee, but also employees of the police department that are held to high standards. The membership has been tracked by the media, and you should be prepared as a public body subject to the Open Meetings Act for people to pay attention to whether or not you attend these meetings. This board cannot function without at least a quorum of you attending, whether it be trainings like this or actually hearing the cases. And there are people that file the appeals and employees that rely on these decisions to be resolved. And those resolutions cannot be made if we don't have good attendance. There's been conversation about the Open Meetings Act and the notice related to Civilian Appeals Board. We do not typically get as much public attendance to these meetings as you might expect. We get quite a few people that comment about police policy, police oversight at our city commission meeting. But as this board has even more, maybe at least a different influence on decisions that are made by the Internal Affairs Department, it's very rare that we have anyone that is just from the public that attends these meetings and issues public comment. So we always invite that. We've done a good job as a city to make these available online with the advancement of technology, but if you have any thoughts on how to make sure the public knows that we're having these meetings, that's important. A lot of times the board will ask, what are we really here to do? And this Civilian Appeals Board has been codified to be an appeals board, quasi-judicial in nature. So you are not truly a fact-finding board. All of the facts that are found and presented to you are done through a different process, and you'll hear more about that. So this board gets to review the facts, make sure that enough facts exist that you can make an adequate appeals decision, and then use the standard that is adopted for similarly situated appeals boards and apply that to the facts that have been gathered. So you're determining whether or not the decision by the Internal Affairs Department in light of all the facts that have been gathered, is the appropriate decision. And we'll talk about the standard that can be applied and what happens if you make the wrong decision, how that appeals of your appellate decision works in future trainings. In 2002 and 2003, there was again kind of a local community analysis about what could or should be done to give this board different types of authority. In actuality, these additional scope of responsibility questions have not been successful due to the collective bargaining process. The collective bargaining process is required when we're talking about disciplinary proceedings for employees. And so the expansion of Civilian Appeals Board's scope of work has not really been the subject of much collective bargaining. And we are currently in collective bargaining. I'm not at liberty to discuss the current position on that current collective bargaining, but we'll update you once those agreements are reached so we can discuss. I'm sure Brandon will talk more about what any conclusions are that come out of that ongoing collective bargaining situation. In COVID, you can imagine we were stalled. We had kind of a change in membership, and we had actually multiple cases coming in. Some of them were related to the civil unrest that happened downtown in 2020. And so the media was paying attention to what felt like a backlog at the time. In all honesty, we were able to get the board members trained up to speed relatively quickly and clear that backlog. And I'm proud of the work that that board did. We've had some turnover since then, and we haven't had quite as many cases come in, but now we do have a case. We are training you as efficiently as possible, and we're excited to turn that case over to you to make a decision. Here are some things about the Open Meetings Act that really need to be considered. Open meetings are governed by state law, require a certain public notice to be given, and as city staff, the Office of Oversight and Public Accountability, together with our office and the clerk's office, make sure that those notices are met. So you don't really have to worry a whole lot about the functionality of noticing and the setup for open meetings. But we do need to have an opportunity for the public to always have a chance to be heard at your meetings because they are subject to the Open Meetings Act. And you as board members can't go home behind closed doors and deliberate and discuss and decide cases. That body of work has to be done in an open setting where the public is free to observe that. I don't think that's news to you. I know that some of that discussion is done as you're onboarding to the city board, but it's worth noting again. We are permitted to do things like trainings outside of an open meeting, so long as we're not deliberating and deciding cases. There could be social gatherings. I like to say Grand Rapids is the biggest small town that I've ever lived in, and I bump into people all the time at the grocery store, so don't be afraid if you bump into one of your colleagues at a grocery store or out to dinner. That's perfectly okay. Now, if there are violations of the Open Meetings Act, those have both civil and criminal consequences. I don't anticipate that will ever happen, but if you ever have questions, ask the law department, ask your board liaison, so we can make sure that you are complying with the Open Meetings Act. The Freedom of Information Act is governed by state law and local policy. And essentially, whenever you're communicating about the work of CAB, you're putting on your city employee appointed official hat, and you are subject to a FOIA. So if you are emailing Mr. Davis, for example, and you're asking questions about a case, those emails may be subject to FOIA, and we would have to review them to see if it would be appropriate to release them. We want to encourage you to ask questions, to email, and to be responsible board members, but just be conscious that anything you do while you're sitting at the dais or while you're communicating about the business of the CAB is likely to be subject to FOIA. The FOIA process is we get those records, we review them and apply any redactions that would be appropriate or necessary. and then we serve those records out to the person requesting. Some things have to be redacted from FOIA or otherwise. For example, individual social security numbers are always redacted from police records or other records. There is very, I guess, hard to explain, but in concept, if you think about criminal justice information being communications on the radio or on paper about someone's criminal history or information that's exchanged during the course of an investigation, a lot of times that's considered criminal justice information, and police are the only department that can have access to that. So if you see a redaction done for CJIS compliance, CJIS stands for Criminal Justice Information Services. The police lose access to that and face criminal fines if they disclose that outside of their department to unauthorized individuals. Crime victim information, the Michigan Constitution requires us, as it should, to treat crime victims with the highest degree of respect to all these processes. So crime victim information is oftentimes redacted. Protected health information is redacted. Compelled statements by law enforcement officers to the employer, so that Garrity statements under Section 8 are also very sensitive, and CAB is one of the very few city bodies or departments that can actually view those statements as it's been negotiated through collective bargaining. And then attorney-client confidential communications are another regular communication that's redacted. One thing that I ask you to keep on the front of your mind at all times is the city's conflict of interest and ethical standards policy. This is also recited in state law. And the purpose is to avoid creating an appearance of individuals using public office for private gain, giving preferential treatment to any purpose or organization, impeding government efficiency or an economy, having a lack of independence or impartiality of action, making government decisions outside of the official channels, or doing anything that could affect adversely the confidence of the public and of the integrity of the city. So, well, you have a list here. I've highlighted the main ones that I want you to pay attention to. Some of them are less applicable. You're not going to get a whole lot of city resources that you would misappropriate for personal gain, but you will get some confidential information during the course of your job. You will be deciding issues that may have parties that have a stake in this that they may want to contact you outside of a public meeting. And so you should be knowledgeable about what these ethical considerations are for your decision making. And again, please come to the city, the law department, OPA, if you have questions, if you feel like you've been confronted with a situation that doesn't feel right, we can help you make sure that you're abiding by the ethical standards that you're obligated to. If you feel like you have a conflict of interest, say, for example, a business is subject to an investigation that's involved in a CAB hearing and you happen to be an employee of that business, those may not always be conflict of interest situations, but if it feels like a conflict, if it feels like an ethical dilemma, you should feel free to contact us and talk about it. Okay, those are the three main policies that I wanted to cover before handing it off to the Internal Affairs Department. Were there any questions on those three main policy documents? Thank you for paying attention. Thanks for listening to some of the history. Here is a visual of some of the state and local legal complexities of the Civilian Appeals Board. Be mindful that we'll be talking about federal law and state law as we get you trained on the other legal considerations. You're going to learn about Grand Rapids Police Department policy and procedures next. And we've talked about 800-02 and the CAB bylaws. I hope you know about the CAB bylaws. Those are kind of our meeting procedural guiding instruments, and we help you navigate through those as well. Brandon Davis is going to cover a lot more about national and statewide best practices for civilian oversight of law enforcement. I will do my best not to do any injustices to what updates may have happened, but there are different cities that have oversight features within their law enforcement community. There are also higher ed institutions that have committees on oversight, and those are things that I'm going to leave to our in-house expert, Brandon, to brief you on during his section. Sometimes I think there's a misconception that there is too little oversight of police in Grand Rapids, but in reality, there are a lot of different agencies and departments that have an eye on police, both locally and throughout the state. I've tried to list as many as I could think of here, starting with the federal and state oversight. You may have seen some of our investigations get handed over to the Michigan State Police under certain circumstances. There's a Kent County aspect where the prosecutor has some level of oversight over the investigations that get submitted to them and prosecutorial discretion. Our city attorney's office, our internal affairs department, OPA, Department of Labor and Relations that I believe is here today too, and you as the Civilian Appeals Board are kind of our local beacons for local oversight. But if you look at the community organizations, we've received recommendations. Individuals from these community partners and groups sit on different task forces. And we can't talk about oversight without mentioning the media that also reports on cases and have different takes on issues, especially related to police in Grand Rapids. So we get a lot of FOIAs from the news media. And then, although it might be one little box on the bottom of this screen, Facebook has really become one of the paramount areas for oversight. And it may not be true oversight, but it's not uncommon to see videos and opinions floating around social media about what people think police could do differently. And so I ask you to consider all of those different oversight considerations. Brandon will highlight this, but I think that our Internal Affairs Department is one level and layer of oversight, and you're going to hear from them just here in a couple minutes. There is the Committee of Police Review that was formed and eventually turned into the Civilian Appeals Board. We have a Public Safety Committee that is part of our City Commission, and that has public representatives on it as well that are non-voting members. We've had different plans and different studies that have helped informed what oversight could or maybe should look like here in Grand Rapids. And more recently, the OPA department was established, and Brandon was hired to direct that department. Okay, this is some specific history dating back to 2001. I would mention this, and you'll hear more about it during the Public Employee Rights Act training. We have had grievances, we have had arbitrations, and we have had different allegations when employees have felt like the process was unfair or maybe out of line with their collective bargaining agreement and their rights as employees. We'll talk more about those specific results and the impacts that they have had on how CAB has evolved over the years during the next session, but I'll introduce them here and just let you know that it has not been as clean as maybe one would hope when you establish an oversight board, and some of those decisions are influential about the scope of work that you have before you today. So for a visual, it would be perfect if we could kind of tell you exactly everything, how it's going to go. If in 1996 they had this vision and a clear path to civilian oversight of the law enforcement in 1996. But in reality, each case is a little bit different. The history that has gotten us to where we are today with CAB has been complex. And so to get from point A to point B, both on a macro level for the Civilian Appeals Board has been up and down. I think it's been challenging, but it has given us a good foundation for the board to do the work that they have to do today. And each case is going to be like that potentially as well. We've had cases where we've had to ask departments to do more investigation so the board can make a good decision. CAB has issued reports that have talked about good things that they've seen from the city and also things that they think can improve. And so we've got to be prepared. We got to be prepared for state law to change. We've got to be prepared for the ongoing development of a rather new department in our city, the Office of Oversight and Public Accountability. And just be open as we work through this process together and help you to be as successful as we know that you can be. That's all I got. And knowing that some people are on tight schedules, maybe we can hold questions and get you the material and then take questions at the end. Is that fair? Okay, thanks.
Forward just like this.
Mm-hmm.
Good afternoon, everyone. My name is Jana Forner, and I'm the lieutenant in charge of the Internal Affairs Unit. Appreciate you all being here today and listening to us talk about what we do in our agents or in our office so that you have a better understanding of what will be presented to you in terms of an appeal coming your way, what we've done leading up to that, and what our policies dictate for us to do for that. Thank you to everyone else who's here as well, and to the 2 board members that are at home watching so that they can get through this as well. I thought it was prudent for you to know who we are, other than just our names, a little bit about our history with the department and where we're coming from as we joined this office. This is, we choose to come to this office. We aren't forced into these investigator roles. So the next couple of slides are just some of our experiences throughout our careers here at Grand Rapids Police. I've been a police officer for 22 years, and probably 15 of those 22 years for me were spent as an investigator in our detective unit. I was an investigator in general case, family services, major case, the Children's Advocacy Center. And then when I was promoted as sergeant, I ended up coming back in and supervising investigators in general case and family services. I've also been through a variety of trainings, leadership trainings, staff and command school, and then some investigations that are specific to internal affairs. I joined the Internal Affairs Unit in January of this year, so it was coming from a criminal investigation side to an administrative investigation side is very different. Some people don't realize that there's a big difference, but there is. There's a lot of different things that you can do on a criminal investigation that you can't do on an administrative investigation or an internal investigation. So it was important for me, and it continues to be important to me, to improve myself and learn more about these internal processes so that we do very good investigations. And I'll let these guys introduce themselves as well.
My name is Joe Daly. I'm a sergeant with the Grand Rapids Police Department. I've been a police officer here for 21 years. The bulk of that 21 years was spent in a uniform on the road and in some form or fashion with our community policing unit, our special response team, or on first or third shift road patrol. In 2017, I was promoted to sergeant and maintained my assignment on the street and went and supervised some third shift patrol teams, our community policing unit for a brief period, and then was a day shift supervisor. In February of this year, I transferred into internal affairs from that role. So this is a brand new experience for me, this side of investigations. It did help me, though, being well-versed in our policy and procedures on the street, to apply that to these investigations that I do now in internal affairs. In addition to that full-time experience, I hold some additional duty assignments here at the police department. I'm a field training officer, or was a field training officer. I'm assigned to our mobile field force unit. I'm also a negotiator. I'm assigned to our honor guard, peer support team, and then I'm an instructor and coordinator with our bike patrol team. So, thank you.
Hello, everybody. I'm Sergeant Mead. I've been with in law enforcement for around 20 years. I was a patrol officer for a long time. I actually came from another department from the east side of the state, came over here, continued patrol. Eventually I went on the special response team and then got promoted out of that to a sergeant position. I spent a little bit of time as a sergeant on the road, night shift, managing a team of officers. I was also a background investigator in that time, field training officer, subject control, tactics instructor, and on the mobile field force unit as well. Some of the additional trainings that I've received, I've been in this unit since August of 2020. So I'm coming up on over 2 years now, so I've done a lot of trainings involving internal affairs. I'm a nationally certified internal affairs investigator. Also, like I said, PBCT certified threat pattern recognition and use of force instructor. Also, just recently, Lieutenant and I went to the National Internal Affairs Investigators Training Conference, as well as a couple use of force trainings and summits and some legal issues around use of force, Garrity statements, officer-involved shootings, administrative bifurcated criminal and administrative investigations. So during my 2 years, I've put a lot of time in training, trying to make myself better so I can better educate and inform my team as well as those officers and commanders that need assistance and information. So.
And you should all have all that information in front of you. I did email out this PowerPoint today, along with our Internal Affairs Unit policy. That also can be found on the city website. The Internal Affairs Unit policy can. I know Mr. Howard, I think you have this now in your email, the PowerPoint. So if you have questions as we go along too, please just go ahead and jot them down, and we can do all the questions that you might have at the end. So just a quick overview of our organizational chart at the police department. Our office, the Internal Affairs Unit, reports directly to Police Chief Eric Winstrom. We also have Deputy Police Chief Scott Reipenberg, who's over the Patrol Division and Special Operations, and then Deputy Police Chief Kristen Rogers, who's over Administrative and Investigative Services. Here's just a look at the city if you've not ever seen this before. These are our geographical service areas and the captains that are in charge of each of them. Those captains are in charge of sergeants and patrol officers who patrol those different areas of the city. And you can see underneath how many sergeants and officers are assigned in each of those places. So the goals of the Internal Affairs Unit here on this slide come directly from our policy, and that's to investigate and promptly resolve qualifying complaints of employee misconduct. In our policy, we do define qualifying complaint, which is an allegation amounting to a specific act or omission, which, if it's proven true, would amount to employee misconduct or an expression of dissatisfaction with a policy, procedure, or practice of the agency. And we do that by maintaining the integrity of the Grand Rapids Police Department through the operation of a competent, objective, fair, and impartial internal investigation and review system. And that's why we wanted to make you aware of the processes that we use to complete these investigations so that you can understand the information that we receive, how we receive it, how we don't receive it, and then what we do step by step after that. It is the responsibility, again, in our policy to receive and investigate qualifying complaints of employee misconduct. And I did just obviously define qualifying, but misconduct could be defined as an act or omission by an employee which, if proven true, would normally result in some form of discipline or remediation under the manual of procedures. We also jointly investigate any notice of claim or civil suit regarding our officers with the City Attorney's Office. We investigate incidents involving the discharge of a firearm, except for the humane disposal of animals. We maintain liaison with state or federal prosecutors while conducting investigations involving alleged criminal conduct by GRPD personnel. So we maintain liaison. They're two separate investigations. There's a criminal investigation, and then there's the administrative investigation. And that administrative investigation that our office conducts is about policy and procedure violations. It's not about, there could be a criminal aspect to it, but it's about whether it violates GRPD or city policy or procedures. We make the procedure for registering complaints against GRPD personnel available to the community. There's a variety of ways that folks can make complaints to about an officer. They can do it through OPA, through the city attorney's office, online, written complaint. They can call it in. It could be third-party complaint. So there's any number of ways. We also have brochures in English and Spanish that we provide to the community so that there are ways for anyone that needs to make a complaint to do that. We maintain records regarding our investigations, so we have our own report system that's separate, that's only accessible to those of us in our office. We maintain all departmental accreditation processes, which is new for our office as of the beginning of this year. So we've taken over some of those accreditation and manual procedure duties as well. We also assist with departmental planning and research projects, which was added to the Internal Affairs Unit as a duty here recently. And we perform any other related tasks as assigned by the Chief of Police. We also do review the use of force reports and the police pursuit reports, which I think you heard about. The training unit does that as well. So those reports, once they're completed, get sent to the unit commanders, to training, to the Internal Affairs Unit, and to the Chief's office for review. So I'm going to let Sergeant Mead talk about the investigative process a little bit, and I might pipe in a little too along the way, but.
All right, so here we are, meat and potatoes, right? So this is what you all want to hear, how this all works out, right? So really it comes down to, we pretty much could take, I mean, if you can think about getting a complaint to us, we'll take it. I mean, if you want a homing pigeon, whatever it is, send it my way. It comes here. So we pretty much take all complaints. There are times where obviously we'll get information from people, and it's different agencies, and you know, we'll get through that and say, all right, this isn't our agency, but here's who you can contact to at that agency, and you can go through them. So like the lieutenant said, in person, OPA, city attorney's office, labor relations, any Grand Rapids supervisor, if they see a supervisor on the road, they can pull them aside. Mail, telephone, internet, snail mail, email, anything new that's out there I don't know about, I guess. So step one, it's listening to complaint. So we'll receive concerns that result from sometimes there are common misconceptions about how we operate. Honestly, law enforcement as a whole, we don't do a great job explaining why we do stuff and the purpose for it. So we'll hear common misconceptions or false assumptions of authority of police, what police can do. Typically that's Miranda warnings are common ones we get, where the officer should have read me a Miranda, and I'm not going to go into the Miranda as a whole, but sometimes it doesn't apply. So we'll explain when Miranda's apply, when it doesn't. Sometimes that's some of the information we initially receive. We'll listen to that information. If there's a qualifying complaint with misconduct, we'll start intaking that. So we'll listen, we'll try to get as much information from that person, their concerns, their what happened, all the facts that surround it. Sometimes we can resolve those before it becomes a complaint. Like I said, if it's something where they were confused about what happened or why it happened or whether it could happen, search by a female officer or search a female by a male officer, those type of things that are allowed by policy. Sometimes we explain to them and they're like, okay, I get it. I wish the cop would have told me that ahead of time, but I get it. So those ones we'll go ahead and deal with, and we'll ask them, are you satisfied now, or would you like to continue? And if they say we'd like to continue, then we continue. So we gather the information, allegations, specific details. You know, the vague information is difficult for us because we have to get pretty succinct information, especially identification and who was involved. That's kind of our big thing, is like, hey, who is this officer? If you don't know their name, can you explain what they look like? Where were they? What part of the city? So we can kind of identify the potential officers. Try to identify any potential witnesses. So we'll ask them, hey, is there anybody that saw this? Was there anybody with you? Anybody that we can reach out to? Establish that clear understanding, right? We want to know exactly what happened and what the allegations of misconduct are, so we can investigate those allegations and address those issues that these folks have. And at the end, we'll do a kind of a summary, like my understanding of what you're saying is, you know, that you had a problem with the way that the officer talked to you and you believed he was rude and discourteous. And if they say, yeah, that's what I'm saying, okay, good. If they say, no, that's not exactly it, well, then we'll kind of try to flush it out even more. after that, we have to evaluate. So a couple things that we learned, and you guys kind of talked about in the last training was, perceptual issues, right? So your brain is an interesting thing, and there's times where if you're under high stress incidents and you didn't necessarily directly focus on the event, or it's something where it occurs quickly, you're spiking your adrenaline and your mind starts to cloud, your mind will automatically fill in blocks of information that you don't have. And it might be a misconception. You might truly believe this is what happened to you. And in actual reality, it's not what really happened on the camera. So there are times where people say stuff like, hey, this is what happened to me. Okay, explain to me. So they'll explain it. I'm watching the video and I'm like, boy, this is different than what they're telling me. So there's sometimes I'll invite them in and say, hey, as long as there's no CJIS violations, it's just them on the camera, I can invite them in and I'll say, come and look at this. Explain this to me. You point out exactly what you're seeing. Tell me, show me where this is at. And I've had many people watch the video and they're like, wow, I legitimately thought what I told you happened. And it's no big deal. It happens. We as police officers understand that under high stress situations, your mind, there's things you don't remember. Maybe you're looking this way, loud bang over here, you look over and you see an accident, and you're like, oh, that was an accident. But you might tell the police officer, oh, I saw the accident. It happened. I saw the car, run through the stop sign. When I started asking you questions, where were you looking? I was over here. I heard it. I looked over and saw the accident. Well, you're not lying to me. You saw the accident, and your mind's perceiving that you witnessed it, but maybe it didn't happen that way. So we understand that. We take that into account. And there's some times where it's intentional, right? I mean, I know it's crazy, but we do have people lie to us every once in a while. So we take that into account. We really look at, was this a perception issue that they truly believe it, and that's fine. We have no problem with that. So then after that, we got to identify the possible officers involved or employees, because we also investigate not only police officers, dispatchers, our forensics techs, so pretty much any employee of the city that works in our department, we will do an investigation on. And then we got to identify the policy violations. So after we identify the employee and we get the facts, now we got to figure out what are we talking about? What violations of the policy are we looking for? We're going to go into classifications here in a bit because we break down our violations based on classifications. So I'll explain those here in a second. But we'll identify the potential classification. Now, early in these investigations, we get preliminary information. What the initial information is might be different once we dive into it, watch the videos. Classification might go up, it might go down, depending on what we're seeing in the evidence. So our bottom level classification is a class 3. We call it an informal violation. This is a violation in which typically can be handled at the supervisor-employee level. It's kind of a thing where the relationship between the supervisor and the employee can be immediately addressed, immediately the conduct can be changed immediately, and we expect our supervisor to do that immediately. So these are those very minor things like simple discourtesy, minor diligence, like you forgot to check a box on a report, something like that. We expect the supervisor to address those, but sometimes we get them into our office, so we'll take them. A lot of times what we'll do is we'll do the intake, then we'll send it down to their supervisor, because truly their supervisor should be responsible for understanding what the issues are with their employees and addressing these concerns, because they might have seen different or same concerns, and now they're seeing a pattern, and now they can send it back to us and we can do a higher level investigation. These are mostly limited to coaching. On these, unless there's a pattern, obviously, then we'll address it and we'll actually take it to a higher class at that point. But most of these are going to be coaching or some sort of training deficiency, so we'll coach it or train it right there, and typically not discipline. Our class 2s and our 1s are what we call formal violations. So these are going to be any serious allegation, if sustained, could result in some sort of corrective action, which is including termination. So they're pretty much everything other than your civil rights and criminal law violations, except for use of force stuff, which technically is a civil rights violation. Insubordination, failure to appear to court, violation of pursuit policy, our traffic accidents, so every accident that an employee is involved in is a Class 2 violation. We will do a formal investigation where we'll do an intake, an investigative report, and then those type of things. Corrective action, if the complaint is sustained, could be from verbal coaching all the way up to termination. Like I said, some of these get automatic training on top of that, so they'll get sent over for training as well as a disciplinary action. Our Class 1 is our highest violation, and those are going to be your civil rights and criminal law violations. So excessive force, racial profiling, falsification of reports, and then obviously your assaultive, racial discrimination, perjury, and false police reports are the ones that are in that category. And obviously you guys will hear the 800-2, the policy that governs you guys. A lot of these violations, these Class 1s, will be stuff that are CAB eligible for first-party complainants. We investigate these similar to Class, they're pretty much investigated the same as Class 2s. So we do a formal, full investigation, intakes, reports, disposition reports, and then action reports at the end if they're disciplined. So if it is a criminal violation, other than our officer-involved shooting policy, which sends out to the state police, we will do what's called a bifurcated investigation, and if there's allegations of criminal misconduct, we would split our investigations. Our administrative investigation would be done by our department, or our office, and then the criminal side could be done by our department, or we could ask for somebody else to do that. Can't remember the last one we've actually had that criminal wasn't initiated by an outside agency already, so I will have to come over that when we get to it. So there is a split, and you guys will learn this in the information with Garrity. There is a split in what information can be shared between the two parties. That's why we split the investigations. We wouldn't do both criminal and administrative because there is some information that we can't share with the criminal investigators. So that's why it's bifurcated. Corrective action on this is same as Class 2. You can go from verbal coaching all the way up to a termination. After we classify our investigation, then we got to do an acknowledgement of the complaint. So Class 1s and 2s, we will make a copy of intake report to the employee. So he'll get notice or she'll get notice that, hey, there's a pending complaint against you. Here's the allegations against you, and that will be that's required by law. Class 3 complaints, we will acknowledge the call, and then if they request, so sometimes our Class 3 complainants will call us, will say, here's my issue with you, and I'll say, okay. And then I said, do you want me to call back after I investigate this? Some of them will say, no, I'm done, I don't want to talk to you again. If they say that, then we don't call them back unless we find something we want to maybe ask some more questions about or kind of explain something else. But if they don't say they don't want to call back, we'll call them back and we'll let them know, hey, here's what we found, here's what happened, here's what corrective action we took, if we did take corrective action, and we'll talk to them in person. So the actual investigation, really, it's similar to a criminal investigation where we're just going to interview witnesses, we're going to review body cameras, we're going to review any cameras that we have access to that we found or were able to get during our course of our investigation. We'll canvass neighborhoods for serious offenses, try to get some additional witnesses, re-interview employee or complainants. If there's we get into the investigation, we're like, oh, we need some additional information, we'll call them back, try to get some follow-up interviews with them. We will, at the end, typically, we will then interview the involved employee. Before that, we'll do the employee witnesses, but at the end, we will typically interview the involved employee, because we've got a pretty good understanding of the case at that point. We'll do that in interview, and that's what's called a Section 8 interview, because it's Section 8 in our disciplinary action in our contract. That's why we call it that. So we'll do what's called a Section 8 interview. It's protected by Garrity, and that's where we'll ask all the questions and figure out that interview and compile that with all the rest of the information, and that's how we'll make a determination of our finding. Article 8, Section 4 of the Grand Rapids Police Officers Association contract talks about the grievance procedure. I'm not going to go too deep into that. You guys should receive information on how that works, I think. Is that right? Yeah. So you guys will get that. So that's, they have the ability to grieve any discipline that we recommend and the chief imposes. as well as further things that are allowed by that contract. And then after that, so the disposition of the complaint, we will do the investigation. We render our determination. So was there some sort of, did the alleged conduct occur? Was the conduct a violation of the policy or procedure? And then was the employee identified and were they held responsible? We've had a few where there's an allegation of misconduct, but we just couldn't identify the employee because of the information we received, and we just couldn't identify him. So at that point, obviously there's nobody to discipline. Those ones we'll do a separate document just to document the allegations, and potentially if there's any policy changes that need to be made, we can review that at a later time. We use the objective reasonable standard or totality of circumstances, which you kind of heard about in your last training. We also implement those in our use of force policies and some of our stop instances where we're talking about, hey, was this objective reasonableness used by the officers? That's how we evaluate our officers' conduct in especially use of force cases, because that's what the courts evaluate that conduct by. So same standard. You know, would a objectively reasonable officer faced with the same facts and circumstances have or act in the same or similar manner? I mean, that's really the standard that we're going to hold them to. Some of our job is understanding that not only are we going to impose discipline, we're also looking to correct action. So we have to look at liability impacts of the city, and if an employee's conduct is in a manner which is going to increase liability for the city, we also have to take that in consideration, and is an appropriate approach to train that person to avoid further action so we're not setting the city up for liability, or is it disciplinary action that's going to correct this? So those are some of the considerations that we look at. So it's typically specifically designed to the employee to address the performance deficiency. So it's not, one size fits all. We're looking at what is the deficiency, what's the performance that they're at, and where were they? Are they brand new to the job? They've been here for 10 years. If they're brand new, we're going to treat that officer a little bit different than somebody who's been working the job for 10 years, because the expectations for that employee and the information that they've received and the training they've received and the education level that they're at is different. So they have to be treated differently. Just kind of like, you guys are new, a lot of you guys are new in this position, we wouldn't expect you to perform day one the same way that somebody's been on this board or in this position for a long time. So we use the same standard. We look at the severity of the offense, experience of the employee, whether or not the employee was trained to the standard. So we can't really hold an employee accountable for an action if they haven't been trained to that standard. And have they received the department expectations? Do the employees understand that? Because again, we can't discipline them for actions if they don't understand the expectations. So those two things we have to take in consideration. And has the employee received additional supplemental training or discipline in the same area? So if they've received supplemental training on this and it's like, wow, this really isn't sticking, well, we got to come up with something else to address this issue, right? Because it's continuous. Our goal is always fair, swift, and certain corrective action to ensure professional performance by employees, as well as increasing the knowledge of all employees regarding acceptable conduct and performance. So then that's really our goal. Is at the end of the day, I want to make sure that all my employees are performing correctly, they know the standards, they're performing to the standards, and they're making our department the best department it can be. Our four possible outcomes for our investigations are unfounded, exonerated, not sustained, and sustained. So unfounded means that the investigation conclusively proved that the acts complainant did not occur, or the acts may have occurred, but the named employee was not involved. So these are going to be where we get the wrong employee. They're certain it's one employee. We got the wrong employee. That employee is not going to be held responsible for an action of another, or it didn't occur. It didn't actually happen. Exonerated means the actions actually occurred, but they were lawful and justified and proper. So use of force, for instance, they complain that they got struck in the common peroneal by a knee strike, and we find out that, yeah, that's true, but they were trained to do it, and that was reasonable given the circumstances. That'd be an exonerated finding. Not sustained is we didn't have enough to prove or disprove the allegations. So there was not just enough evidence for us to say, yes, it happened, or no, it didn't. So it's not sustained, and then sustained is obviously, there's a violation of policy, it did occur, and we've taken appropriate actions. So, Class 1s and 2s, if you remember, those are the more severe ones, Class 1s being the highest severity. Those get reviewed on a bi-weekly meeting with our chiefs, our chief, deputy chief, labor relations, and city legal. We go over recommendations for disciplinary action, and then they make a determination based on what the discipline is going to be. We go through a progressive discipline system. So we look at past disciplinary action, similar disciplinary action in the same circumstances that this employee showed, and that's how we make a determination on how the discipline is going to happen, along with the other factors that I just talked about. Class 3 complaints, those are going to be our informal complaints that we expect our supervisor to address when they see them on the spot. And those ones are reviewed by the IA commander, so Lieutenant Forner, she reviews all those, and then she signs off on those investigations. Our notification process, our Class 1s and 2s, the complainant employee receive written notification of the disposition of the complaint, as well as a copy of the complaint disposition report and a summary of investigative findings by the mail. So they get that through the mail. And then CAB eligible complaints also receive CAB appeal forms from our office and instructions on how to file those appeals. So how they can get in front of you guys. And then our Class 3s, like I said, we'll try to contact them via phone if that was the request, or sometimes they say, no, we just want to hear from you from email, or send me a letter. So we'll figure out which way they want to be contacted. We'll do that. Advise them of the disposition of the report. All right. You want me to go through these, or do you want to? Okay, all right. So here's our annual report numbers, kind of a review for the last 3 years of kind of where we're at as far as our total complaint numbers and, kind of the breakdown of what those were. So you go back 2019, we had 182 internal and external complaints. We had 108 formal Class 1 and Class 2 complaints, 31 informal complaints, and then 43 administrative documents. 2020, COVID, we had 130 internal and external complaints, 76 of them were formal complaints, 22 informals, 32 administrative documents, 2 department complaints. 2021, we had 141 internal and external complaints, 74 formal, 39 informal, 23 administrative documents, and 5 department complaints. So if you look, the formal numbers are tracking pretty consistently. As well as the informals. I mean, they all stay roughly about the same, and you'll see that here in a second. For our sustained complaints are similar as well. So we got 2019, we had 77 sustained Class 1 and Class 2 complaints. 9 were generated by the complainant, outside complainant, citizen, and 68 were internal employee generated complaints. So, which means that internally in our department, 68 complaints that were filed by internal, typically supervisors, we investigated and sustained. That's actually quite a bit. Some places have come in and looked at our department and done some research. We're astonished by that number because it's very high compared to a lot of other agencies. So tracks well with 2020. 55 internal employee generated complaints were sustained. 2 were citizen generated. 2021. 54 total. We had 6 citizen-generated complaints that were sustained, 48 internal employee-generated complaints. This is kind of the breakdown of what the discipline was from those Class 1s and 2s. So from 2021, we got verbal coachings. We got 3 from Class 1s and 18 from Class 2s. Some no action. I think we'll just go over the notable ones here. We did 17 total supplemental trainings for violations, 4 suspensions on Class 1s and 2 suspensions on Class 2s. Written counselings, we had 19 total, and written reprimands, we had 4. 2020, let's see, we had 1 resignation, 8 supplemental trainings, 2 suspensions, 13 written counselings, 10, I don't math well, 10 written reprimands that year. So those numbers are tracking fairly similar. And then 2019, we had 1 resignation, 8 supplemental trainings, 6 suspensions, 1 termination, and 13 written counselings. So the numbers, if you look, through the past, they track pretty similar across the board. And with that, is there any questions for us? And I don't know if, Brandon, can the other 2, are they able to email you if they do? We can have you can ask questions so everybody can hear it, or, I know they probably haven't, but if they do.
If they choose to, they can.
I just want to
don't
make
know
sure
the
everybody
law.
heard it. Yeah.
And if they don't, we will follow up with
Yeah, absolutely.
any questions.
Yep.
And there's also, the next page has all of our contact information too, so they can either go through you or through Phil or contact any one of us as well, if you have specific questions.
As you think about potential questions, and I know that some of you are on a tight time deadline here, one thing that's nice as you go through the cases is this group will usually be at the podium to answer any specific questions that you might have about IA policy. They're not here to introduce new facts to the investigation, but a lot of these concepts we're able to take a deeper dive on when we're talking about a case. For example, some of the findings like exonerated, not sustained, you might think you know what that means, but actually seeing it applied in a case, you might have some questions about why it was applied in that particular instance, and we can do a legal opinion to help you better understand that, or more reasonably, the IA group will be at the podium to help answer any questions you might have.
Are there any other questions? Would you all explain what an administrative documentation is and how a complaint can become an administrative documentation?
Yeah, absolutely. So we've got administrative documents and department complaints. So administrative documents are typically documents in which the complainant calls up and says, a high-risk stop was conducted last night and I didn't like it. Okay, explain what happened. So we'll go through the whole process and find out that, all right, everything that they just told us is inconsistent or is consistent with our training and how we expect our officers to perform based on what they've told us. And if that's the case, then we'll do what's called a administrative or a department complaint, and we'll draft up basically a document outlining what their concerns are, outlining what the officers did, and at the end, it's basically used to evaluate whether or not there's some policy issues or some training issues that we need to address. So if we see multiple complaints of the same nature or some issues as they're talking, going, yeah, that's a pretty good concern, or yeah, we didn't think about that, we can take those documents into account, get with the training unit and say, all right, maybe we should address this or revisit this idea. Our administrative documents are typically internal department consumption documents are of a sensitive nature. Something of let's say it's an employee issue, maybe they're going through a bad divorce, maybe there's some conflict there that we want to document for issues that might transpire down the road. But we don't necessarily want it to be obviously wide known, or we don't want to share those documents. So they're internal. We want to make sure that the employees' dignity and sensitivity is protected, but we want to document in case something does happen down the road where it comes up and we're questioned, well, did you know about this? Well, yes, we did. We have this document. So those are ADs, or administrative documents.
I did get an email from Michelle Williams. She was curious about, for employees assigned to the Internal Affairs Unit, can you discuss the training that you receive related to cultural competence, diversity, equity, inclusion, anything along those lines that Internal Affairs employees receive?
So we're required by CALEA standards every year to go through a bias-based policing training, as well as an ethics training. So the whole department receives that every year. We don't specifically in this group go to a specific training on those topics, but a lot of the trainings that we've been through have those topics integrated with them. The National Internal Affairs Investigators Conference had some bias-based stuff, and FBI guy came in and talked about bias-based policing and impacts in internal investigations. The certification course that I went through, and I believe the one that Sergeant Daly went through has a portion of that for that certification. Department-wide, like I said, we do quite a bit of training on it for everybody. I'm missing.
That's it, unless
we haven't
done any of the webinars on that yet.
No. So that's, I guess the general answer is we don't do specific, although it's integrated in a lot of our trainings we go to.
Okay, go ahead.
I have a couple questions. I want to go back to where you talked about qualifying complaints, because that was said a couple different times. What is, in a nutshell, what is a qualifying complaint? And what would distinguish a qualifying complaint from a non-qualifying complaint?
So if the allegations of misconduct that are alleged could be true, that would be a qualifying complaint. So the distinguished nature here that the policy is trying to address is we get sometimes complaints that are off the wall. For instance, we get, hey, the chief is an alien and he's sneaking in my bedroom, poisoning me at night. Those are complaints by somebody, but they don't qualify. I guess it would be misconduct if the chief was an alien sneaking in, I think. But those are the things that we're trying to address is, hey, this is a little bit out of our bailiwick here. We have to be able to address and change employee conduct. And some of those things that we get are a little bit out there, I guess.
And then I had a question about CAB eligible complaints. And there is a complaint that goes all the way through the process, and say that complaint comes back with exonerated or one of these other qualifications, but the complainant or the citizen still wants to push forward. Would that become a CAB qualifying complaint, or is it based on where you all draw the line as to what is CAB qualifying, or does that go through OPA?
So the CAB qualifying complaints are based on 800-2, and those are the ones that are outlined.
Right.
So I think to answer your question, what I think your question is how does that process work as far as getting notice and whether or not they have the option to do it? And so anything other than a disciplinary action, so a sustained complaint, would result in a first-party complainant who's been harmed by or injured by the actual officer. So if I use force against you, I'm a first-party complainant, I'm CAB eligible, we'll send you the paperwork, you'll be able to fill it out. As long as I wasn't held responsible for that action, any of those other three, you have the ability to and please correct me if I make a mistake here, but you have the ability to appeal that to CAB, and then that case can come in front of CAB.
Okay.
Is that?
I think that's basically correct, yeah.
All right.
So CAB has you're right that it is specifically explained in 800-02, which we'll talk more about in a future training again. But the short version is there are categories that are explicitly stated that CAB has jurisdiction regarding. I think the heart of the question you're asking is related to who determines if they're CAB eligible, and the GRPD does the categorization as it relates to the findings, right? And that's why there may be a time where someone thinks, well, this should be CAB eligible, but there was not a finding related to a category that specifically fits. However, after that's done, when an appeal is filed, both OPA and the law department look at it to make a determination on whether or not it fits within the policy. We don't make the determination on the original categorization of the case, but based on the categorization that was done by GRPD, we review it to see if it fits within the policy.
Thank you.
To that end, and we may be getting off in the weeds here, I know we have some other training coming up, but as I understand the policies I read earlier today, is that if it's, correct correct me if I'm wrong, if there's a substantiation that essentially says that the event happened and there's discipline is going to take place, and then that is not CAB eligible.
Yeah, that's correct.
And so in those instances where there is, say, one aspect that is substantiated, but another aspect which is not, is that still CAB eligible? Or-
Yeah,
or is that?
so a lot of times we'll get multiple issues on a single complaint, and there's a lot of times we find our own issues, so we'll add those on. So let's say it's a use of force and they're discourteous. So they call them a bad word and then they use some sort of force. So we'll do the investigation and we break those apart. So it's not just one or the other. And sometimes, honestly, we'll get a couple where we have to break the same complaint down and sustain one part of it, and then the same complaint sustain or not sustain another part. So if they say they use force on me, force is pretty complex. So let's say they use a knee strike on my knee, and then they punch me in the face. All right, well, we might have to look at that and say, well, the knee strike was good, and that's sustained or not sustained, but that punch in the face, that was no go. So now that's sustained. So sometimes even within a complaint, we have to break down the actual event several times. So it can get complex, but yes, let's say they did call the person a bad name, but then the force was good, they called them a bad name, but the force was bad. Let's do that. I sustain the bad force. I can't do that. It's got to be good force. I sustain the bad language, and then the force is, I determine the force is good, but it's CAB eligible. Just because I sustain that lower level, that CAB issue can still come in front of you guys. That was a lot of parts there, a lot of moving parts.
So like if there's two, short version of it, let's say there's A and B, right? There's A and B allegation. A is sustained, B is not, and B is CAB eligible. B still gets to come to CAB, but A can't be considered. That makes sense?
That was beautiful. Yeah, I should just defer.
No. Are there any other questions? Okay, seeing none, we'll thank the Internal Affairs Unit and move forward with the meeting. So the next section on our agenda is old business. I don't believe we have any old business to discuss. So we'll move from that to open discussion. Is there any discussion on any topic that the board would like to have at this time? Hearing none, we'll move to the next space, which is public comment. There is no public, and therefore there is no public comment. We'll close that public comment period. That takes us to the adjournment, and we will adjourn this meeting at 5:19. Thank you.